well, healthy, and continuing to stay sane. Today's Friday. It's May 8th. And, by now, virtually every business has been impacted by COVID-19 in some way. And it's truly remarkable how this virus crosses all markets. It ignores industry lines and indiscriminately impacts everyone to some degree. And given that businesses can live or die by their contractual obligations in normal times, today, COVID-19 has made virtually all contracts just that much more difficult to perform, enforce, or get out of. And for those very reasons, I'm excited to have this conversation with Johnny Yeh. He's a leading contract law attorney with Emergent LLP for a technical dive into the world of contracts. Now, we're going to talk about what clauses to look for, what language to pay attention to, and which contractual buttons you may be able to push to make your business do better through this challenging time and, of course, beyond. We'll talk about real estate, lease contracts, vendor and supplier contracts, franchise contracts, and general business contracts that you may have with another entity. So if you own a business or if you advise business owners, this conversation should be especially relevant. And with that being said, I'd like to welcome Johnny Yeh. Hey, Johnny.
Good afternoon, Roman. Thanks so much for having me here today.
It's great to have you, and thanks for taking some time. And today we're going to talk about contractual obligations under COVID-19. And so I guess just to, Johnny, kind of cut to the heart of the matter, what's the most important thing should parties be looking for in their contracts to see if there are any safety valves in place?
Well, Roman, that's a great question. And right off the bat, any party that's involved in a contract and is thinking about, well, maybe this contract is too burdensome now, maybe there's a way for me to get out of it, they should be looking through their contract for something that's called a force majeure clause. And what a force majeure clause is, it's just a contractual provision that allows one or both of the parties to avoid having to perform their obligations if there are some specific enumerated events that are outside of their reasonable control, if those events occur. And some of these events that are in a typical force majeure clause would be things like a riot, a labor dispute, an act of God. Sometimes it'll be something more generalized like a disaster. And obviously, very timely in a COVID-19 era, some of these force majeure clauses also have references to pandemics and epidemics. These force majeure clauses also have kind of a safety release in the sense that there's oftentimes like a catch-all provision that says other things that are beyond the reasonable control of the parties. So it can be kind of expansive depending on context. And I would say that when people come to me asking about their contractual obligations and how they might get out of it, over 50% of the time at the outset of the conversation, they're bringing up the term force majeure with me. And the reason why is because a lot of these people are business owners, very smart, very sophisticated people. They've either Googled their situation or they talk to other people in their network. And there's just been a lot of discussion about these force majeure clauses. Now, it's the case that not every contract is going to have a force majeure clause, but this type of clause it's kind of a boilerplate standard provision. And so it can make its way into any type of contract, really. It can be a commercial lease, as you mentioned earlier. It could be like a supply contract, a franchise agreement, a business or asset sale agreement. Since it is boilerplate, it does make it around, so to speak. And when I'm looking at these clauses and talking with my clients, these are the things I really want to impart to business owners. I can't stress these points enough. First, in looking over this clause, you want to go over it with a fine-tooth comb because the language really does matter. And if you don't satisfy some of the requirements in the language, you could end up waiving some of your rights under the force majeure clause and then not being able to invoke it, which is going to prejudice you substantially. The other thing I usually that I want people to know about is that there's an entire body of law kind of behind the force majeure clause. That's how it's sort of implied there by law. And it's not necessarily obvious from looking at the language. And there's just many, many points to consider. In this respect, if anyone is working with an attorney, they'll probably get advised on these other issues. But I just want people to understand that when looking at the force majeure clause, be aware of those two things right off the bat.
So thanks for that, Johnny. So force majeure seems to be obviously a very large and important provision in it seems like most contracts or most business contracts, but it's the language around the force majeure clause that may have some pitfalls that may not necessarily be apparent whether to enforce that main force majeure clause or get relief from it. What should business owners be kind of paying attention to when they're looking at the force majeure clause?
Oh, this is a great question, Roman. So when you're actually reading the force majeure clause, the things that you want to think about, there's a couple of things here, and let me talk to you about sort of the big 4 points that I am really paying attention to when I'm advising my clients and they're looking at their force majeure clause. If you're looking directly at the contractual language, one thing to be aware of is that a lot of force majeure clauses actually contain notice requirements. If you're aware of a force majeure event that happens, you've actually got to tell the counterparty, hey, look, this event has happened. I think it's an act of force majeure. I think that I might need some relief in the future from some of my performances. Sometimes people overlook that, and that's unfortunate because you can end up waiving your rights. Another little nuance here is that sometimes the notice provision, you have to give notice within a certain amount of time after you become aware of the event, even if the performance that you're worried about actually engaging in is several weeks or even months down the line. So there's a timing element here. So that's one thing that business owners really have to pay attention to. Another aspect of just sort of the plain language of the contract that sometimes I lock onto, and it's a little bit more esoteric, but it's certainly something worthwhile considering, is a choice of law provision in the contract. In most cases, I would say about like 95% of my cases, maybe even more, the parties are just engaged in California. They're doing business in California. They're both located here. And so the choice of law is just going to say California law applies. But I've certainly had clients and been in situations where the client is more sophisticated or they're engaged in cross-state transactions. And then the governing law is actually the law of a different state. Now, some people think that this may be academic, but I think most lawyers are aware that it is not just academic. It can actually have real-world implications for the contractual obligations of the party. For example, there are certain requirements in a force majeure clause that I'll cover in a moment relating to trying to mitigate your damages that aren't present in other states. For example, they're not present in Texas. So in the 30 seconds it would take for you to confirm whether or not you're dealing in California law or not, that's a worthwhile investment because you're going to have a better understanding of those rights. In terms of other things to consider that are always on my mind, there are two that really stand out. And one of them is the notion of damage mitigation. And that's just a really fancy word for the following proposition. If you see a harm coming your way and it's going to do injury to you, then you have to do your best to try to avoid the consequences of that injury. The law wants you to do that because they presume if you're taking these efforts, then overall damage across everyone will be less. And this applies to force majeure clauses as well. So if you see a problem that's arising, you have to try to actually avoid it. You can't just sit on your hands and say, well, it's a force majeure event. Now I don't have to comply with my obligations. And if you can avoid the damage, then what I would recommend is you document what efforts you made to mitigate and why you weren't able to do so. And let me give you an example of just mitigation. I think this will offer something that's a little bit more concrete, especially when we're talking about the abstractness of legal principles generally. Let's say that you run a business and you're like an electronic boards manufacturer. You take components from your suppliers, you build these boards, and you provide it to other people. And because you're providing them to essential services, you are also an essential service, just to give this a COVID-19 flavor. Now, let's say one of your component suppliers actually goes out of business because, everyone is facing tough times right now. And now you don't have some of the components to build these boards. Now, the question is, can you just, now let's assume that you could go and get the components from someone else, maybe at somewhat of a increased cost. In this scenario, can you just sit on your hands and say, well, there's a force majeure event. It says pandemic in my force majeure clause. I'm not going to do anything. I don't make as much money. The answer is really no. You have a responsibility to actually try to avoid the consequences of that event. And I think that's the right decision under the law. I think it's a good policy, but people need to be aware about that because that's not usually stated in a force majeure clause. It's a legal principle that's kind of tacked onto it. That's something that some people don't know. The other and final issue that I kind of want to bring attention to for business owners, and I'm talking to business owners about this as well, is this notion of causation. And again, it's another big law word, but it just basically means exactly what it sounds like. There's an event that happens, and as a result, it causes a harm. And here's how it applies to force majeure clauses. If you're going to claim that something like COVID-19 has damaged your business, then part of the calculus is that something else hasn't caused your damage. And here's a pretty direct example. Let's say that in the COVID-19 world, you're operating an essential service, you have a lease, it imposes operating hours, and so you're kind of required to remain open. But because of COVID-19, business is slow, maybe you don't want to catch the virus, and so you just make the decision, even if I can remain open, I'm just not going to remain open. I'm just going to shut my doors. And then I'm going to use my force majeure clause to try to get out of this issue and try to, avoid paying the landlord or whatnot. You've created a bit of a problem for yourself there, because arguably the cause of the harm isn't COVID-19 anymore. It's your independent business decisions. And so I'm always counseling people and cautioning them to be aware of these issues, because there's a wide interplay of factors. And if you're not aware of them, then you can kind of stumble and really step into it and make an error. And that's why consulting an attorney can be helpful when looking and evaluating a force majeure clause.
Thanks, Johnny. That's a deeper dive than I've heard covered before around force majeure clauses, because generally it's just the clause itself that people pay attention to, or some attorneys direct their clients to pay attention to, but they don't always cover kind of all these important tangential areas of the law that are seemingly even more or potentially more important than the provision itself, because they can obviously trigger some further consequences. But the next question I have in my mind is, do all contracts have force majeure? Or if they don't have that clause, is a business effectively stuck? Or are there other provisions or other safety valves that they might have access to?
Another great question, Roman. And the answer is there are a good number of contracts, and many of them that have crossed my desk, where there just is no force majeure clause. It's unclear to me whether it's just because they originally drafted it and they kind of forgot about it. It's a little bit more nuanced than some other boilerplate provisions, but there are definitely contracts out there that don't have it. But that doesn't necessarily mean that people are just out of luck and don't have any safety valve, because there's a variety of just legal doctrines that can come into play that might offer them a way out of some of their contractual obligations. And there's been a lot of discussion about three doctrines in particular. Three are impossibility, impracticability, and frustration of purpose. And for purposes of talking about these doctrines, you can kind of lump them into two sets. One is impracticability and impossibility put together, because they're sort of like two sides of the same coin, and we'll get a little bit deeper into that. And then there's frustration of purpose, which is separate, but it's related but separate and distinct, and has different logical underpinnings. So with respect to impossibility, impossibility is really designed to address those situations when the goals or the core objectives of the contract can't be accomplished. At that point, your contractual obligations can become voided out, and you don't have to perform. And oftentimes, in the case law traditionally, it's something physical that has happened. Let's say that you have a building and there's contemplated work for the building burns down. Then in the situation that's true impossibility. That's to be contrasted with other situations where the person making the promise to perform just can't perform himself for whatever reason. Impossibility is not designed to address that circumstance. And I think another example is probably kind of helpful here. Let's say that you say, hey, I'm going to do some work on a building, and you are very, very eager and a little bit over-enthusiastic, and you overpromise. And you say, I'm going to do it by this date certain, but there's just no way you're going to do it. In a situation like that, the doctrine of impossibility is not really going to come in and rescue you, even though as a practical matter, you're probably never going to be able to accomplish this. It's because, again, there's that distinction between the base objective of the contract versus just someone not being able to perform under it. In contrast, if the building had burned down before you started work on the building, then at that point, it truly is impossible. And so this notion of impossibility can work to get you out of your contractual obligations sometimes. But admittedly, the field in which it operates is a bit limited. Now, over time, over the course of the last century, courts kind of broadened impossibility out to make it a little bit more lenient. And now it covers situations where there's an occurrence. It's something that you guys didn't predict, something you didn't anticipate. And as a result, complying with your obligations would make it just unreasonably difficult or expensive. That's called practicability. And that's how come I said that there were two sides of the same coin. Because if something is unreasonably difficult or expensive, it can get you out of your contractual obligations. Usually it doesn't apply just because something happens and you're less profitable. So it has to be a pretty significant occurrence. It has to have a significant effect before courts are really going to entertain using these types of doctrines. Now let's talk a little bit about frustration of purpose, because as I mentioned earlier, it's distinct, but it's kind of related. It's focused not so much on impossibility or impracticability. It's focused more on something unforeseen has happened. And as a result, the value of the contract is no longer there. You know, when you're entering into a contract, you're trying to get something out of it, but the value has been impaired and it's essentially valueless at that point in time. At a minimum, it's got to be a substantial frustration. So again, this isn't a situation where as soon as you become unprofitable, you can rely on this doctrine. In fact, all three of these doctrines historically have been pretty narrowly construed by the courts. So there is a safety valve available to parties in contracts, but whether or not you can actually rely on them is very, very fact intensive. And it really requires you to demonstrate that it's unforeseen and the impairment is significant.
And just, Johnny, to clarify, are these doctrines in our contracts, or do people just need to be aware that there are these doctrines in the law that they should be thinking about or asking for some guidance on?
Sure, Roman. No, these doctrines are not in your contract. I think that I have heard of people complaining about some people trying to list out some of these doctrines in their force majeure clauses, and most force majeure clauses that I see don't really reference these doctrines. And I think that's probably not good drafting, truth be told. But generally, no, these are not going to show up in your contract. They're just general principles of law, animals of common law that just came into being because over time the courts have adopted these doctrines, which they think actually make some business sense. And they really do make business sense. But again, for just your layperson or a business person, someone who doesn't have so much exposure to the courts and the law, they may not know about it. And they should know about it because it's something to consider if they're talking with a counterparty about getting out of their contracts.
And it sounds like these are kind of broad business contracts that these doctrines or the force majeure clause can apply to. Can you take a moment to either confirm if that my understanding is correct, or if there's specific contracts that would only have these provisions or these doctrines apply to them?
No, these are general contract principles. So the wide majority of contracts should have these doctrines in play. I'm not aware of any particular doctrine that would exclude any of these doctrines. And frankly, I've never seen any provisions that excluded the application of these doctrines. There can be situations, I think, where you've contracted for something, where you've agreed to accept certain risks, which kind of remove a party's ability to rely on these doctrines. But there isn't a specific set of contracts where these general principles wouldn't apply. They would apply across pretty much all contracts.
Got it. Well, that's helpful. And thanks for going over that. You know, one of the most common questions that at least I come across is from, say, a commercial tenant that is wondering if they can get any kind of rent abatement based on, you know, any of these doctrines that you just mentioned or some of the issues that businesses might be experiencing. What are your thoughts there? And, you know, is there an avenue for commercial tenants that, you know, they can get rent abatement?
Roman, very great, very timely question. And I think that's on a lot of people's minds, especially because a lot of businesses just can't operate and can't open its doors to the public. So absolutely, very timely question here. My view on this is that the holy grail for a tenant in this respect is to get a rent abatement during the time that COVID-19 is affecting their business, but then to be able to come back onto the premises and, you know, reopen shop when everything is said and done. I think that's what a lot of people are shooting for. I think the ability to pull this off is relatively low. I think that there's a lot of uncertainty and a lot of legal doctrines and their applications that aren't fully tested. So I think if a tenant really wanted to pursue this and even press it into litigation, they've got to have a strong stomach. But there might be some avenues. And so let's explore this from the context of those of the subjects that we just touched upon. Now, first, let's look at the force majeure clause. I think that the majority of commercial leases, especially sophisticated ones, will have a force majeure clause. Now, the difficulty for a commercial tenant in this respect is that in pretty much all of these force majeure clauses, the obligation to pay rent and to pay other charges is actually carved out. So right off the bat, you've contracted with the landlord to pay your rent even if a horrible disaster occurs. So I would say in the majority of cases, the inquiry more or less ends there. There's an agreement there. And so I don't think that a tenant is going to easily be able to get an abatement short of trying to negotiate with the landlord and the landlord essentially giving like an accommodation or some form of concession. I will also note that if you have a force majeure clause, it probably overrides certain of the doctrines I talked about earlier, like impossibility and impracticability. I think it's a little bit more of a gray area whether or not it overrides frustration of purpose, but I think an argument can be made there because if the intention of the parties is that you're going to pay rent no matter what, then I think the court is going to enforce that. With that said, not every commercial lease is going to have a force majeure clause. And if you don't have a force majeure clause, then the question becomes, well, can I rely on these other doctrines to save me? Let's talk first about impossibility. As I mentioned earlier, one issue with impossibility is that the impossibility has to go to sort of the impossibility that is the core object and the goal of the contract. And so we had the example of the building burning down, and we contrasted that with the promisor, in this case the tenant, just not being able to perform. Mm-hmm. Well, a tenant might say, well, I just can't pay the rent, I don't have the cash or whatnot. But generally, historically, how impossibility has been interpreted, it's not really going to act as a safety valve for the tenant. So I don't think that impossibility is really something that is going to get the tenant out of the liability for paying rent. I think impracticability is a little bit closer to the mark, but I still think it's hard to rely on. And here's how I view it. In order to pull off some defense based on impracticability, you have to have a reasonable difficulty or expense. But in COVID-19, the issue is that your rent hasn't really fluctuated very much. It's still the exact same rent. So if you show up in court and you start saying, well, it's really difficult, it's expensive, and the court sees that the rent is the same, then I don't necessarily think that impracticability is going to be something that you're going to be able to sell very easily. I think that, courts may be more flexible after COVID-19, after the extent of the pandemic. But I think it's yet to be fully determined. Next, let's talk a little bit about frustration of purpose. So I actually think that's a little bit closer to the mark. And there's actually case law to support the position that maybe you can rely on frustration of purpose. But one problem that I have is that you might still not be able to pull off what I termed the holy grail. And here's the reason. In order for frustration of purpose to really apply, what you have has to become essentially valueless. And there are some businesses that can remain open during COVID-19. And there might be situations where you wind up in court and the court says, well, I know you had some problems for like 5 months, but your term was for 5 years. Well, in that case, then you may still have value on the contract, and so you don't have really a frustration of purpose. And lastly, there's case law also indicating that if you have the ability to sublease, then maybe it reflects value. So my whole point here is just that if there is some value under the lease, then the problem is you might not be able to rely on frustration of purpose for the doctrine. There's also this really interesting question of what your remedy is, even if you can pull off and show that there's been a frustration of purpose. I think the better part of the argument is that your contractual obligations just completely terminate. Your lease would effectively end. And that's not really what people are looking for in the COVID-19 era. They want the rent abatement and they want to be able to come back. Now, I don't want to be all doom and gloom, so I will say that there are authorities out there that arguably would allow something like a temporary frustration of purpose. So there is a universe where you can pull together arguments and make the argument that the tenant should be absolved of rent for a time period and then come back in. But again, it's very, very much untested, and it's been the subject of a lot of discussion among many attorneys, because every tenant seems to want to know the answer to that question. And it's a completely valid question, and I understand why they're asking that. So that's kind of my view of whether a tenant can get out of its rental obligations. I think, again, highly fact-dependent, law is uncertain, and it relies upon piecing together various legal principles that a court may or may not accept at the end of the day.
Johnny, I'm sorry, I had some technical issues and had to drop off for a second.
No worries at all.
No, I appreciate it. Thanks for rolling with the punches. It's interesting how these things do happen sometimes. One of the questions that I have as I was listening to you is, if someone has the force majeure clause, but that they have kind of more aggressive kind of, not necessarily desires, but they weren't able to reach some of the agreements that they thought of, some of the concessions. What should business owners think about in that regard, or what can they do?
Well, I think in that case, they have to go and approach the counterparty to see in the first instance whether or not they can broker some type of resolution or some type of compromise. And generally, when people come to me and they ask, what steps should I be taking to begin this process? There's a few steps that really jump into my mind. The first thing is this. Obviously, they've got to carefully review their contract and their circumstances. And they want to they basically want to pull together all of the best arguments they have, given those circumstances, given the language of the contract. Then they know what ammunition they have to bear on the other side and what arguments they can actually make. The second thing I always tell people to do is just document very carefully how COVID-19 has affected you. We talked a little bit earlier about, sort of like the mitigation issues, but documenting is important. You want to be able to point to real financial data, which most businesses should be able to do, showing what type of losses that they've suffered. I think it's also helpful if they have even just anecdotal information from like their vendors or their clients, indicating that their either supply chain or their extended network has been affected by COVID-19. I think all of that is very helpful, because if you're going to go to the other side and you're going to start asking for accommodations and concessions, you better believe they'll want you to be able to pony up information showing that you've actually been harmed. That's one of the first things they're probably going to ask you. And so it's good to be prepared in that respect. I think the next thing to think about is really engaging in an analysis of your relationship with the counterparty. I actually think that aside from the law, aside from the circumstances, this might end up being the most important factor. And the reason why is because the other side's willingness to negotiate and talk with you is going to be contingent on their own expectations. For example, if the counterparty is, say, one of your vendors or works with you to manufacture something, and they've been working with you for 20 years, you've done good business, they might think, 3 years down the line, this COVID-19 pandemic will be a very bad but distant memory. And what will happen there is they'll think, well, I want to give an accommodation because I want to work with the other side. And that can be very, very powerful. You might be able to leverage that. I've also seen situations where, for whatever reason, the parties are very, very friendly. I would almost consider them friends. That can be very powerful too. I tend to like arm's length transactions. But if the other side has, a lot of goodwill and good feeling towards your client, that's something to consider too. And then sometimes it's just an arm's length transaction. And it becomes a negotiation, and that's all right. And then at that point, it's just kind of dollars and cents. I guess the last thing is really, how do you approach the other side? Now, I think the majority of business owners tend to approach the other side directly in the first instance. And I think that's a good idea. I have seen situations where if someone has hired a lawyer and they've just sent off a letter and the letter just says, I'm not going to comply with my contractual obligations. And that always gives me pause. And I don't really like that approach, because I think in the first instance, the parties have to talk with one another to see if they can get to a compromise. Because as soon as you introduce a lawyer, you're going to burn through whatever goodwill you were able to develop. So that's usually the advice that I have for my clients. If they want a lawyer on the side to try to advise them, make sure they don't make any statements that's going to harm them later on in case they need to go to litigation, that makes a lot of sense too. And I encourage that. But in the first instance, it's about negotiation. It's about trying to get to a resolution. And frankly, in the COVID-19 era, what I'm seeing among my clients is that counterparties are willing to talk. They want to work something out because it's so unprecedented. And let's face it, as just an economics matter, who wants to throw more money away in litigation? Not a whole lot of business owners want to do that. And so I actually appreciate the fact that there is some positive collaboration. If all of that falls apart, then you might have to take more aggressive action because some things just won't get resolved. But that's how I've been advising my clients when approaching the other side. Like there's an avenue here to get to some type of compromise.
And Johnny, can you talk for a moment? What happens, or I guess, what should business owners be thinking about if they're about to enter a contract? Because we've talked a lot about sort of how our contractual obligations are being affected by COVID-19. But these are, again, existing contracts that are in place that may be preventing us from fulfilling our obligations under the contract, or maybe we're looking for some relief. But talk for a little bit about what should business owners think about as we look ahead in either signing these documents or thinking about how to structure them better now that we know that this can happen.
Great question as well, Roman. I think really what they need to think about is how they're going to structure their force majeure clauses. So as I mentioned, some contracts don't have force majeure clauses. I think that after COVID-19, a larger proportion of them will have them, if not something like in the 90, 95, 99%, just because it's such an important provision. So the first thing I would say is make sure that you have a force majeure clause. And if you don't have a force majeure clause, then you're going to be creating problems for yourself. And you're actually kind of seeing this throughout the industry. For example, the California Association of Realtors back in March issued a coronavirus addendum to their regular purchase agreement. And that was essentially a force majeure clause. It's on everyone's mind, so you should have one. The second thing that I would say is that when preparing these force majeure clauses, you want to be very, very specific about what the enumerated events are. As I said earlier, there are some force majeure clauses that says pandemic, it says epidemic, and that's all well and good. I don't think it's crazy for someone to say pandemics, including without limitation, anything caused by COVID-19 or additional outbreaks by COVID-19. And I think you even take it one step further. Look at all the consequences that has arisen as a result of COVID-19, like the shelter-in-place orders, quarantines, effects on travel, the government forced closures of certain stores. I think all of that should be laid out in the contract. Because if you fail to do so, then you risk a situation, and there's case law to support this, where your language is just too vague, too boilerplate, and then you don't get the benefit of the force majeure clause, even though it looks like you should. So specificity, I think, is the name of the game here. The third thing I would point out is that put some extra thought into your catch-all provision. Most people think of the catch-all provision as kind of a throwaway provision. It's just, for other stuff that I'm not thinking about right now. But you should have one, and you should also structure it in the right way. There are actually certain canons of contractual and statutory interpretation that could artificially constrict your catch-all provision. So you might want to say something along the lines of other things beyond the reasonable control of the parties, whether similar or dissimilar from the foregoing list of events. Having that catch-all provision, I think, is going to help a lot because, no one really, back in November, no one really thought too much about COVID-19 or there'd be a pandemic. So the next major disaster may not be a pandemic, but it may be something else. So you want to make sure that you're protected. And last but certainly not least, and I actually think this is the most important one, is that in your force majeure provision or in conjunction with it, you want to figure out how to allocate risk. Because again, most of these provisions are boilerplate. They just say it excuses obligations. Now, after COVID-19, I expect that people are going to be more specific about what happens. For example, if there's like some store shutdowns that, you can't operate your business, then in a commercial lease, it might be the situation where the tenant pays some proportion of the rent and the rest is deferred. Maybe even some of it may be abated. In like a supply contract, it may be a situation where someone is required to find like another component supplier if one of their suppliers shuts down, but they only have to spend an additional X amount of dollars in order to do that. Otherwise, their performance is excused. So what I do expect to see is I think force majeure clauses will start allocating risk more precisely, There's going to be a lot more thought put into what should happen if there is a disaster. And I ultimately think that's a really, really good thing, because I think that's going to maximize the likelihood of both parties surviving the next COVID-19.
So it sounds like there'll be more specificity and more thought put into these important clauses that up until now might have been more boilerplate. And it's really
absolutely.
Yeah.
I think that it's funny, because I think that's the general consensus, that at least in the legal community, is everyone is going to be putting a lot more attention on these clauses, because it's really one of those things that everyone just kind of ignores. And I think probably if you're a business and you've been impacted by a force majeure event in the past, you're probably negotiating more aggressively. But now everyone is impacted. And so I think there's going to be a bit of a sea change in how these things are structured.
Well, and I wonder also if some of these doctrines that you talked about that sort of surround the force majeure clause as a whole, that have so much value in them that perhaps a lot of business owners didn't even know existed, let alone how they applied to their business and their contractual obligations. So I wonder if going forward, and hopefully folks that are watching this video or will see it down the road, will become more aware of their presence and will ask their attorneys or their legal representatives to advise them through, in the construction of these contracts, or if they've got an existing contract and navigating their obligations under those contracts.
That is absolutely true, Roman. In fact, I've already heard and seen some lawyers make the comment, you might actually be better off in certain cases with these common law legal doctrines like impracticability and frustration of purpose than with a poorly drafted force majeure clause. I'm not so sure I'm there yet, because I do think the force majeure clause does certainly have value. But by the same token, yes, there's definitely an interplay between them. Mm-hmm. And when you're talking with your lawyer, you really want to understand, if I have this provision, right? I mean, what am I giving something up? Am I no longer allowed to go with an impracticability defense? Does it affect my frustration of purpose? And I think a good lawyer is going to say, well, let's talk about what you're worried about, and let's put it clearly in the contract. Because when you're in front of a court and the court is using these doctrines, you don't have a ton of control over how it's all going to play out. But in the drafting phase, when you're actually getting into these contracts and allocating risk, I understand that there may be unequal bargaining power sometimes, but you do have input. You can specify what's going to happen. And I think that everyone should be taking advantage of that opportunity up front. And yes, they should be in close communications with their attorneys, just to make sure that they understand how this would play out later on if there is a litigation.
That's very, very helpful. And one of the things that I do want to mention, especially right now, for those of us, or for those of you watching who don't know Johnny, as well as I do, and I've had the pleasure of not only working with Johnny, but also having heard from people that he has worked with in representing his clients, but also people that he was up against in litigation. And it's very unique to hear the consistency with which both sides refer to Johnny. And no matter the side that they were on, they always praised his technical skill in knowing the law. And I'm especially thankful that you went into some of these less known areas of the law that may help business owners make better decisions and navigate this time and through and beyond it. So before we sign off, I do want you to take a moment and tell our viewers, what areas of law do you really specialize and practice in? What kind of questions should people be coming to you with? And what kind of problems can you help them solve?
Great, absolutely, Roman. So I'm a real estate and a business litigator, which basically means emphasis on the litigation, because one thing our firm really likes is just being in court, making motions, taking depositions. Now, on the real estate side, on the residential part of my business, a lot of it relates to broken real estate sales contracts, non-disclosure of defects. I also get involved in property damage disputes and disputes between HOA and TIC owners. On the commercial side, certainly you have non-disclosure cases as well. But I also end up handling a good number of commercial landlord tenant matters. So always happy to provide guidance there. On the business side, sometimes I get involved in business sales disputes, partnership fallouts. There's a lot of room in the business world, obviously, for litigation to occur, especially when a business enterprise falls apart. And we do a lot of that work over at Emergent. So if anyone has that type of dispute and that type of situation, absolutely they can contact us. We'll give them whatever guidance we can. We're always here to help out the client.
You mind if I throw your email up on the screen?
Absolutely.
Awesome. So there's your email. And, you know, I, in particular, want to thank you for taking the time to be here, because as a litigator, you make a living by fighting a good fight and being in the court. And a lot of those cases generally, you know, have gone through at least some kind of a process that ended up in courts. And it was really nice of you to actually take the time to help our viewers avoid getting themselves into a situation where they would find themselves in court or in litigation. So thank you. Any other thoughts? Any other kind of last tips that you want to leave our listeners with?
Sure. You know, this is what I'd like to say. I mean, in the COVID-19 era, I understand that everyone's stressed out, everyone's worried. And I think that probably a lot of people are panicking because it feels like the world is, you know, more or less falling around them. But insofar as they're running businesses and they have contracts, what I would recommend is they take a step back, take a deep breath, and then proceed very methodically, very tactically in the manner that I laid out. Because I think it's all of these tactics that will really translate to positive results at the end of the day. And hopefully it's through some negotiated resolution with the counterparty. And, you know, lastly, I just want people to know that lawyers like myself and some of my very skilled colleagues, we're here to help and we want to help. So if anyone is worried or panicking, reach out to an attorney, because I think the majority of us are really here just to provide the best guidance possible. And, you know, together we'll get through all of this.
Well, it's nice of you to end on a positive note. Thank you for hanging in there with our tech glitch. I appreciate it. Hopefully I didn't miss too much of what you were giving as good advice to folks on the line and also those who will be watching afterwards. And so I really want to thank you again for taking the time and walking us through some of these less known but very important areas of the law.
No worries, Roman, and thanks so much for having me. I really appreciate everything you're doing to set this up. And it was great being able to speak with you about these topics.
Thanks, Johnny. Well, everybody, be well. And until the next time, we'll see you later.
Take care, everyone.